Okay, good afternoon, everybody. It's good to be here. These have been really good presentations. I'm used to the old CLEs, the old way the CLEs are done. They're not nearly as exciting, and these have GIFs and all kinds of fun charts. But hopefully, this makes a little sense as to why we're going to now talk about government benefits in a CLE that we've been talking about, modernization and technology. I think all of you that practice personal injury will attest to the fact that one of the biggest time drains on your time as you finalize a case and settle it is all the time that you or your staff spends figuring out liens, figuring out the government benefit issues that pop up, and then figuring out, okay, now that I've got the liens done, what does my client need to do to protect their benefits that they're receiving? So I know it's a bit of a jump from what we've been talking about, but hopefully by the end of this, you'll realize you can save a ton of time and increase your productivity and efficiency by making a few changes to the way you handle the government benefits issues that pop up. Just as a brief introduction, so Toombs Maxwell is our law firm. We handle the legal side of the legal issues that come up at the time of settlement. So special needs planning, government benefits planning, that type of thing. Then we also have a settlement planning firm. We call it Amicus Financial Advisors or Amicus Settlement Planners. And we handle the structured settlement annuities and kind of the financial side of things. So let's see. So really when we're talking about government benefits, as you settle cases, there's two parts. There's resolving the liens that pop up, Medicaid, Medicare, FEBA, private liens. And then there's the post-settlement benefits eligibility issues that your clients are facing. All right. So we'll talk about both of these really quickly. So what do these things have to do with, growth through modernization, which is the theme of this conference? Well, resolving liens always slows down the process. When your clients get to the end of a case and you want to give them a settlement check like Rush was talking about, but you have to tell them we have to wait 3 months before we can get this Medicare lien resolved and then come in, they're not happy, or 6 months or whatever it is, they're not happy. And then the reviews are worse and they're frustrated. And so if you want to get those good reviews, this is something you need to figure out. And then also, a lot of clients may not even express this to you, but if they're on Medicaid or SSI or another needs-based government benefit, they're really worried about losing that benefit. They don't want to lose it. And a lot of times they don't even understand that there's things they can do to protect those benefits post-settlement. So a lot of times you'll hand them that check and then they'll say, by the way, my husband's on SSI. Is this going to be a problem? And then you're like, oh, crap, I don't know. And then you try to call someone and you figure it out, and it's a mess and it slows things down. So if we can come up with a way to where we can figure out the liens so that when the case settles, those are resolved, and also help those clients understand that, yes, when your case settles, if you are on a needs-based benefit, there are things you can do pre-settlement to make sure that you don't lose those benefits after settlement. So we'll talk about lien resolution real briefly. These are the various types of liens that I'm assuming you have. I just wanted to use this feature once. Medicaid, Medicare. We're at a tech facility after all. Usually at these CLEs, nothing works, and this is kind of fun. So these are the various liens that you're going to run into. And I don't know any attorney who understands all of the different ins and outs of all of those different programs and how to negotiate with each and every one of them, because they all have different rules. They all have different, pitfalls that you need to navigate. Okay, so the old way of resolving liens, and I imagine most of you are doing it this way, is you've got a paralegal that you hate because you make her do this, and you have that person, hey, call Medicaid, call Medicare, figure out this lien, see what you can reduce for this client, or whatever it is. Somebody, either you or somebody in your office, has the task of calling these lien holders, figuring it out, and negotiating these liens. Okay, that's super time consuming. It takes you and your staff, your focus off of what you do best, which is representing clients and getting the settlements. But that's the way most people are doing it. The option 2 is to just outsource that. Why are you spending your time and your firm dollars resolving these liens? Yes, you have an obligation to make sure those liens are resolved, but that doesn't mean you and your staff have to be doing it. Lien resolution companies, there's a lot of different ones. We have worked with a lot of them. Some are better than others. But generally, the statistics show that they get much better results than your paralegal will. And then it just completely removes that burden and the time drain from your firm. And then it can be expensed as a case cost. You can bill it as a case cost to your firm or to the client. So it's not coming out of your firm's take. There's actually a Utah ethics opinion on this exact topic in 2014. And the two questions were asked in that ethics opinion. Can a lawyer appropriately outsource lien resolution? Yes, it is ethical for a personal injury attorney to engage the services of a lien resolution company. Okay, is the treatment of the lien resolution fee appropriately treated as a cost to the client? And again, yes, if properly disclosed in the retention agreement, fee resolution services may be included as costs to the client. So that's the place you need to start, is with your retention agreement. Put a couple paragraphs in there, or a paragraph that talk about, look at the resolution of your case. We're going to hire X company to come in and resolve whatever liens might pop up. And the companies charge different ways. Either it's a flat fee, or they might take a contingency of what they save. So if, for example, if your client has a $75,000 lien and that company can reduce it to $25,000, they've saved the client $50,000. They take a 10% contingency fee for what they saved. Other companies, charge just a flat fee depending on the type of lien and that kind of thing. And so we can help you kind of decide. If if you're not sure, give us a call. We can say, okay, what kind of lien is it? What are you working through? And then we can kind of point you in the direction of a couple partners and providers that we work with that are good in each area. We don't really do this in-house anymore. We kind of dipped our toes in and realized it wasn't our core competency either, and we kind of hated it. And so we've found partnerships that with each particular lien that we go to.
This is about titled about government benefits, but you guys deal with private long and short-term disability carriers, health insurers.
Yep, private liens, all those. All those types of liens are part of this, and that takes your time and your staff's time too. So not just government liens. So that's step one. Okay, you got to resolve the liens, and you all know that, and that's part of your practice is resolving the liens. Step two is this part. Don't stop planning. Don't stop believing. Don't stop planning. And a lot of attorneys do. They get to the liens are resolved, and now they get to the end of the case, and they think, hey, I'm going to now give my client a check, and then they're like, oh, dang it, are you on any government benefits? As they're handing the client the check. That's a terrible way to go. That's a recipe for disaster. You're going to get bad reviews. Clients, we ask this question a lot in some of the different events we go to, but could sending a settlement check to your client do that client more harm than good? And absolutely it can. We have several cases of clients that have found us, not because our website's great or because our Google My Business page is great. I've learned a lot today. But we have clients from all over the country that have received a settlement check from a mass tort or whatever it might be, and they will just kind of Google in receiving a settlement, SSI, and somehow they'll call us. And we'll get calls and they'll say, hey, I just got $42,000 from a TVM settlement or whatever it is, and I'm on SSI. Is that a problem? And so we have to tell them, yeah, that's a problem. And then we try to kind of, put the milk back in the carton and help them out however we can. But that's an issue. And those calls kept happening. And so we thought, all right, there's got to be a better way, right? And so we developed a process that I'll talk about here in just a second. Another question, how much money can a client receive in a legal settlement before jeopardizing his or her Medicaid or SSI benefits? Anybody of you know? $1. Exactly right. Exactly right. Most people say, well, $2,000. And $2,000 is how many is the amount of assets that an individual can have in their own name before they lose Medicaid or SSI. But if they have $1,999 in their account and you send them $2, right, or $1, then and that crosses over into the next calendar month, then they've just lost benefits for that month because they have more than $2,000 going forward. So, really any settlement of any amount, you need to make sure that your clients are educated and they know what's going to happen with their government benefits or the government benefits that anyone in their household is receiving. So it's not just your client. If your client's husband is on SSI, or if they have a daughter on SSI that's living in that same household, it's a household test. So even though your client isn't on any benefits and you think, yeah, we've screened her, it's fine, and you send them money, you might still get a call from an angry client. whose husband just lost their benefits. So you might be thinking, okay, but how often does this actually happen? How often do my clients actually have benefits that could be jeopardized? So in about a sample of about 3,000 settlements, the general population is in gray, just in the US. There's about 25% on Medicaid, 3% on SSI, 2% receiving housing assistance, and 16% just in the general population receiving food assistance. Of settlement recipients, personal injury recipients, those numbers are way higher. 40% of your clients are receiving Medicaid, 25% are receiving SSI, 35% are receiving food assistance. So this is an issue in more cases than you probably realize. So making sure that they don't lose those benefits is a big priority, okay? So maintaining benefits, you at least have an ethical obligation to make sure your clients' benefits aren't lost after settlement. We believe you have a legal obligation. There are cases that talk about failure to inform liability where attorneys have policies have paid because they haven't gone through this process at all and given their clients money who have lost benefits. If you've got a client that has a brain surgery or a back surgery or a shoulder surgery coming up and they're relying on Medicaid to pay that, and suddenly you gave them a settlement check for $28,000 and they then lose that Medicaid and then we've got to go figure out how to pay, they're not happy with you. And those reviews, I don't know how amazing Podium is at hiding bad reviews or whatever, but they're not happy and they're not going to leave good reviews. Okay, so let's see. Okay, so now what are your options in terms of helping clients maintain those benefits? So just like with the lien resolution, the old approach is that there's somebody in your office that kind of screens them, or you've got some kind of system where you can kind of screen the client for whatever benefits they're receiving, okay? But that takes your time, takes your staff's time. This is also something that you can totally outsource and not have to worry about. Have somebody else take care of for you, okay? So our firm's not the only firm that does this, but I'm going to switch forward. What our process does, and we're working with FileVine actually to create an integration where this is literally like a 3-click process. You get to a certain point of the settlement phase, a little reminder pops up, you click a few buttons, and then this process takes over, and that's all you have to think about. So the first step is, we collect, our law firm, this is our process. We collect information about your client's benefits, their benefits and the members in their household, okay? We then document that back to the client and back to your firm. If those clients are on benefits that will be lost, we send a letter to your client and to your firm explaining what they need to do in order to protect those benefits, okay? Whether that's spend it down or set up a trust or whatever the case might be with that particular benefit. And then we help that client make sure that they know how to implement whatever it is they choose to do. And so it just depends on what benefit they're receiving and what they choose to do. But if they want to just spend it down in that month they get it, then we provide them with instructions on how to do that appropriately. If they want to set up a trust, they have an opportunity to then set up a trust, okay? But they've got a letter from an outside firm that protects your liability and also gives them the education they need in order to make these decisions. So that's kind of the process we've come up with. So if we go back, let's see. So what would happen is your firm would have its own little unique landing page. So if you're using FileVine or whatever CRM, it pops up that, hey, this is the time of the case to do this. You click send, a little link goes to your client. They click on it and they go to their, the name of the firm is at the top. It just says, hey, welcome to this homepage. You're going to go through a little assessment. It's run by this third-party law firm. They go through the assessment. We then go through this process, generate the letter, and then your firm has the liability protection it needs, and your client's educated and know what they need to do in order to protect their benefits.
Does this have to be done before you put money in your trust account or before you hand the client a check?
So generally with government benefits, the money can go into your trust account and then fund a special needs trust. If it's an annuity, then it does need to go directly from the defendant to the annuity company. Most firms do this right at the time of settlement. So, I mean, they're taking care of the liens, hopefully, a long time before that. But once they know the case is going to settle, that's when they send this link, or that's when the little notice in FileVine or whatever pops up, hey, send the link. Let's make sure we understand the benefits they're receiving. Because this only takes, I mean, this takes a couple of days for us to get the letter back, and then we can do our thing while you're handling the release agreement and that kind of thing. So that was a really fast kind of 10,000 foot overview of what you can do, hopefully, to not spend so much time dealing with the liens and dealing with your client's government benefits issues, and helping them all along the way understand, look, we got it. We know you're on SSI, or we know your child's on SSI. We can still get you a good settlement. Don't worry about that. We've got something in place that can help you post-settlement to take care of all that. So this has been a fascinating presentation. I learned tons from Podium and tons from Filevine. Hopefully this is something that can save you a bunch of time as well. So with that, I'll turn it back over to you, James.